Good morning. So thank you very much for asking me to speak about this, and thank you very much to the presentations we've already had. That's been really interesting. I've noted down some very relevant points. Yeah, so I think I'm going to do something that's a little bit of different sort of approach here, and I've really come at this from thinking about the two concepts of today and of this session. You know, openness, open data, and privacy, and really in the context of my organization, and in particular my work with my organization. So yeah, so as a bit of context, so I work for the National Library of Scotland. The National Library of Scotland is a legal deposit library in Edinburgh and in Glasgow. So that obviously gives us an entitlement to collect copies of works that are published in the UK and Ireland, both in print form and in non-print form. So a large part of our collections are increasingly born digital, websites and ebooks and e-journals and so on. We also have audiovisual content and imagery content, and sort of a wide range of content beyond the traditional paper book. And we also have archival collections. So we're one of the largest archives in Scotland, and so we've got a major archival collection as well. I think these figures are probably out of date, but something in the region of more than 24 million items. Around 4,000 new items are coming in every week, and about 80% of that is through legal deposits. So the bulk of the materials are new publications that come in the door in terms of pure volume. And yeah, I guess the context of this is the organizational setting. And so I'm thinking about our collections, and I'm thinking about a lot of the points that my colleagues have just raised in the preceding sessions. You think about metadata and context and risk management, but you can also think about the types of data that we have and where private information or personal information might be. And just to highlight again, you know, the complexity and the variety of formats. You know, if you think about images of people, can obviously be personal, and it can obviously feel private, and it's very different to manage archival records that contain images of people, for example, versus the sort of spreadsheet style data you might gather contemporaneously from data subjects. So just to reiterate that vast range of data formats, and of course the point about scale here being that it simply isn't possible to look at all this content. A lot of it is you know, legacy. It's obviously archival. It's not created by ourselves, and it's been gathered from a variety of locations at a variety of period of time. A lot of it is published, and a lot of it is unpublished, and those come with their own particular challenges. So that's the context. And the final context I wanted to give before I go on to sort of the points that are highlighted in my title is what I do at the National Library, because I think that's really interesting when we're talking about this subject. So my role is Rights and Information Manager, but what that really means is two of the things that I'm responsible for are copyright and data protection. So I'm the data protection officer for the library, and I'm also the person responsible for copyright policy and so on. And I think the interesting thing there is that I'm having kind of two hats on when I'm looking at this sort of content, and you know, one focused on the intellectual property and one focused on maybe on data protection side. And I think it's an interesting thing that you get at the size of and type of organization that we are, that we're a big organization. We're a national organization, but we're also a small organization. We're only about 250 odd staff. We're not large in the scale of you know, the likes of the University of Edinburgh, for example, or the British Library. So there's an interesting, you know, situation there where you've got a wide range of things to look after in terms of subject areas: copyright, data protection, 24 million items, a huge number of collections, but you don't have maybe vast teams of people. So you're limited in your resources, but you're also spanning across a lot of different content. A lot of my colleagues will be working in a lot of different areas quite frequently, which maybe you know, causes that sort of cross examination of subject areas more frequently than maybe in other organizations. So I was just thinking about the logic here of open data and privacy, and I wanted to sort of just go back to basics, really. I think this is a really useful way to think about things. And if you just go to the open definition as a starting point, you know, open data and content can be freely used, modified, and shared by anyone for any purpose. Sort of the simplest of the open data, the open definitions, and they've got a sort of slightly longer one and then an even longer one. And that's just one way to think about what we mean by openness, but I think it is a quite useful one. It's about free reuse, modification, and sharing of data. I think we all can sort of get on board with that. So, logically, in the open definition sense, and of course, it may be in the open data sense, openness is largely about intellectual property rights. And then a lot of what we're talking about is the licenses or the lack of licenses or the rights information that comes with data or comes with content that allows you, in an intellectual property sense, to make use of that content. So the obvious examples of things that, the Wikipedias of the world and ensuring that data that is made available comes with sufficient open rights information that on the one hand permits you to do things with the content, but on the other hand actually makes it clear what you can and can't do. It places the relevant restrictions. For example, the attribution element of a Creative Commons attribution license, reminding you or requiring you as the user to provide attribution as the one, in that case, limitation on reuse. So I think openness, I put my copyright hat on and sort of compartmentalize these things a little bit, but I think openness, okay, it's first and foremost, it's thinking about intellectual property rights, it's thinking about reuse rights, it's thinking about the communication of that information. And then privacy. So we're talking about open data, we're talking about privacy. And immediately I think, well, privacy versus data protection. And maybe this is me getting over semantic here, but I do think there's something really to unpick there. And I mentioned I'm the data protection officer, so I'm immediately putting in data protection. But privacy and data protection are not necessarily the same thing by any stretch of the imagination. Privacy is just to take a dictionary definition to keep ourselves simple here. Someone's right to keep their personal matters and relationships secret, and you could quibble with this, and you could find different ways to define it. But it is broadly about that, and I think data protection is different. It's broadly the law that concerns the proper processing of personal data, specifically of living individuals. So you can actually see quite a lot of difference there. And one of the first things I always say when I'm doing data protection training for my colleagues is that data protection is not about keeping information private. There are times, absolutely, when data remains private, and there might be data protection reasons for that. But data protection is about regulating and structuring the processing of personal data of living people. It's about using personal data. So I think it is just an interesting point to remind ourselves that there's a lot more to privacy and there's a lot more to data protection than each other. And you get the sort of Venn diagram overlap moment there, I think. And there's plenty in those outer circles for us to think about. So data protection isn't the same as privacy, even though that we maybe talk about one and meaning the other and vice versa. So I think this is what leads me on to what I sort of titled my presentation around, which is this idea of confusion and conflation. And I guess I want to stress this is entirely understandable and it's entirely logical and is a positive thing in a way, and it makes perfect sense. But I guess I wanted to share as a sort of foundation setting for this conference and for this workshop for you, what I find myself doing a lot with our organization, our collections, and those 2 points I've just raised there about what openness is and what rights are and what privacy and data protection are. And I do find myself talking in and dealing with colleagues and members of the public and anyone I sort of engage with around areas of confusion and conflation. And this makes sense. This is because these issues, these matters tend to arise in contemporary materials. So matters of openness, matters of privacy, matters of data protection, they tend to overlap in contemporary materials. Now, you can have intellectual property issues, and you can have therefore openness issues in historic documents and in very old documents, and you can probably arguably have privacy issues. You maybe can't arguably have strict data protection issues because, broadly speaking, our laws relate to living people. So there will be a point at which data protection laws don't apply, but you certainly will have all of these matters in contemporary material. So the newer material is most likely to have intellectual property issues, and therefore you're most likely to be dealing with openness issues in that. And I include digitizations of historic materials when I talk about contemporary materials there, often an area that we're dealing a lot with openness. And that material, contemporary materials, the material that's obviously most likely to have privacy and data protection matters because it's most likely to relate to people who are or may be alive, or issues that may or may not be current and therefore more sensitive for individuals. So I think that's one area of conflation and confusion. It's not necessarily a problem in and of itself, but it's something that I notice a lot. And one of the reasons why I think I notice it a lot is the way that, and I'll say we, misuse controls, and we do ultimately the wrong things with certain tools. And that's why I've sort of started with these strict definitions of openness and so on, because we've got to keep, I think, a very clear understanding of what openness and particularly open licenses and licenses and copyright tools are about, and what data protection rules are, and what privacy matters are. These are three different things. I think that's really important. They exist oftentimes in the same material, but they are not the same thing. There might be overlaps. There might be very, very valid reasons why you want a restrictive license on content, why it's not open in an intellectual property sense. For example, someone else owns the rights, but that is nothing to do with privacy or with data protection or the personal information. And similarly, the inverse can apply. There may be plenty of content where there is personal data in it, or it is sensitive or private for other reasons beyond personal data or beyond personal data law reasons. But that has no effect on the intellectual property, and therefore it should have no effect necessarily on the copyright license that you do or don't apply to that content. Now, you should exercise, I don't want to say control exactly, but the proper restrictions around access and use of this content. But I think it's vital that we don't conflate the tools. So, we don't use copyright tools to to squash the round hole of data protection, as it were. And just to wrap up, this isn't an impossible task. And one of the things that we're looking at in the National Library is making use of something called Right Statements from rightstatements.org, which is a consortium that's provided sort of template copyright statements to use with your collections. These aren't licenses, so they're not Creative Commons licenses. They do not issue rights, but they codify the way that you can communicate the intellectual property status of content. And the real value, I think, in this context of these tools is that they have three categories. They've got in copyright notices, no copyright notices, and sort of ambiguous, uncertain notices. And the ambiguous, uncertain are very useful for when we talk about our collections because they're so big and we don't know a lot of times. But I think for this context, the no copyright is really useful because these provide ways to communicate that there maybe is no intellectual property issue here. You can still get that vital information across. It might be sort of a form of openness in an intellectual sense, but there may be other reasons why reuse is restricted. And these could be for commercial reasons or for contractual reasons, but they could equally be for the reasons that we're more interested in here today, for example, sensitivity of information. So that's all I wanted to cover. I think I've disappointed in some ways because I've not provided any images of collection items, so I do apologize for that. And I've provided more dictionary definitions than anything else. But I guess what I really wanted to stress here was give the background in that one organizational sense and sort of set some frames, hopefully, for the further conversations that we're going to have here. And I would stress most importantly that I think it's really vital that we keep these three things. What I see as three things, but there are many more of them probably, but I think we keep these concepts separate, and most importantly, we don't use tools that are for one thing for another thing, because I think that can lead to real challenges. So thank you very much. That's what I wanted to cover today.
Thank you very much, Fred. There's time for just a quick question. In the US, currently there is a movement to declare personal data and thus privacy as a property similar to data. What are your thoughts on this based on your talk?
Oh, it moved so to assign data as property. Well, I mean, that's interesting. I don't know anything about that. That's the first I've heard of that, so I can't hugely comment. But I guess it does seem very similar to the sense of intellectual property as a property. So copyright is property, and I guess what just immediately springs to mind are the challenges that you get. So intellectual property is property, and I think we can all relate to the incredible challenges we have dealing with material, whether it is or isn't in copyright, at least any of you who have. And as soon as you create property, I guess the caution is it's very difficult to take that concept away. So you have to be very, very careful about that. That's why, one of the reasons why we've got longer and longer copyright terms as time has gone on, because you've given property to people and you can't take it away. So I don't have anything more to say on that because I haven't seen that, but I think it's just, I immediately see some challenges